All right, our top focus at this hour. The Supreme Court has upheld the key provisions under the Prevention of the Money Laundering Act, which were challenged by a slew of opposition leaders. Now, in a very significant verdict today, the Apex Court has upheld the Enforcement Directorate's power of arrest, the strict bail conditions and the expansive definition of the proceeds of the crime. Now, the top court has ruled that the money laundering impacts the sovereignty and the integrity of the nation, and stringent measures are required to deal with such a serious offence. The Supreme Court also quashed the petitioner's plea of making contents of the ED information report known to the accused in the case. It said that the disclosure of reason at the time of the arrest is enough and a report need not be produced to the accused. The verdict comes as a big setback for the opposition politicians who are facing a probe by the Enforcement Directorate. And among these were some who had in fact filed a plea in the Supreme Court challenging the country's Money Laundering Act. And on this very note, let's first listen in to the reactions coming in on this big story.
Court has just now upheld the PMLA and the ED's jurisdiction, and the Supreme Court has said very clearly that they have that jurisdiction and PMLA is within the ambit of the legal ambit in which it is working. It has been upheld by Supreme Court, and we should respect the Constitution, we should respect the law, and we should respect the law of the land.
Supreme Court also having the duty to examine whether this government of India, whether these agencies are misusing the power for political purposes.
Question is, if you see that in a parallel statistics that today itself, that the ED has taken more action in the last 5 years or 6 years than it has taken in the entire preceding 10 years. It's gone up by something like 42 times. 42 times. So that is what speaks for itself. The question of use and misuse would rest on the premise of more data like this. Do you require either the previous regimes were all foolish, they didn't apply it, or this regime is on some other mission? So you have to come to such conclusions.
All right, and I'm being joined by my colleague Meenakshi Bhanja live on the broadcast, who's reporting from the national capital and tracking the story very, very closely. Meenakshi, please take us through the contents of this key judgment that has been delivered by the top court.
Well, yes, you see, this is over 500 plus page ruling that has come by from this three-judge bench composition of the Supreme Court. We are in possession of the ruling, and the important part, like you have referred to earlier, has been how the Supreme Court has upheld the stringent provisions of the PMLA. There were a batch of about 241 petitions, mostly filed by the accused. We underline for our viewer that the PMLA is a special law. It is a special act which is carved out to deal with certain niche offences, and these petitioners were assailing certain provisions dealing from Section 3 to 5 to 11 to 19 to Section 45 of the PMLA, which includes a range of powers that has been vested with the Enforcement Directorate, which currently is probing a lot of allegations pertaining to money laundering and other such related allegations, specifically with regards to the opposition parties and some leading opposition leaders in India. So with regards to that, the Supreme Court has today very categorically upheld that there are certain safeguards that are already made out within the ambit of the PMLA, and with that the Supreme Court has upheld the stringent provisions of the PMLA, which gives the Enforcement Directorate unbridled powers insofar as making an arrest, a seizure of property, or getting a confession, and also, sees to it that bail conditions are very hard and bail is very difficult to come by if anybody is been slapped with any charge again under the PMLA. Furthermore, like you were referring to a little while earlier, the Supreme Court has said that as far as money laundering provision is concerned of this particular act, money laundering is no less heinous than terrorism. These are very scathing observations coming from this 500-plus judgment of the Supreme Court, where the court is saying that money laundering activity has a transactional impact on the sovereignty and integrity of countries. So therefore, that provision which deals with money laundering has also been kept untinkered by the Supreme Court, and this gives a boost to ED, because remember, as we speak, there are several cases slapped against leading opposition leaders.
Correct.
That the ED is in the midst of investigating. So had Supreme Court today made any adverse comment or tinkered with any of these provisions, then the ongoing investigations definitely would have taken a hit.
All right, Meenakshi Bhanja, appreciate you joining us with all those key details. All right, and on this very note, I'm in fact being joined by another gentleman to share his 2 cents on this entire story, Mr. Ashutosh Shrivastava, advocate from the top court, Supreme Court. So a very, very good evening, and thank you for your time to Mirror Now. Now, I want to begin here by asking you that how do you view this judgment? Do you think somewhere this is a big blow to the constitutional rights of an individual, and in this particular case, the alleged accused?
PMLA is a 2002 act, and since then nobody thought of making any amendment or changes in the act itself. So it is being continued in the similar manner. Now, so far as the powers of the ED officers are concerned under the act, see, they have the powers under Section 50 of the same act to summon anybody or to have the search and seizure of certain documentations and others. They have the powers under Section 5 to have the provisional attachment of the properties. See, it is not absolute. After any, if a person is aggrieved by any such order or action of the ED, can obviously approach the concerned court and can ask for the indulgence of the court to supervise the issue and to pass certain directions and orders to the ED, which is happening since long years, and this is being followed in the similar manner. Yes, it is expected out of the ED officers that they will use their powers judiciously, and they will do nothing injustice to any of the accused for that matter. Obviously, they have the powers as per the act itself, and this is what the Supreme Court has clarified after examining all the documentations on record, after hearing both the parties at length, all their arguments, all their reasonings, and then the Supreme Court reached to a conclusion that obviously the ED has the powers as per the act. See, the courts are not making laws. The courts are only executing what laws have been passed. The courts have to only see if any law which has been made is not unconstitutional, or it is not against the principles of justice and the
All
Constitution of India. And this is what the court has seen. And after having regard and going into the depth into the matter, the court decided that yes, the powers of the ED officers cannot be snatched away, which has been given by the act itself, which was enacted in 2002. And accordingly, the court passed an order. If anybody is aggrieved, then can approach the court. See, there could be a case, a particular case in which the power has been misused or something. So in that case, a person can approach the court to have its indulgence, which is happening as of now. But there cannot be a blanket kind of an order where the powers can be snatched away and this kind of offenses are happening. See, everybody cannot be the culprit, but whoever does it, for them only the law has been enacted.
All right, sir, but you know, this judgment, this judgment, I completely get your point, but this judgment also comes in at a time when, several opposition leaders and in fact human rights bodies have been echoing the constant misuse of the central agencies. And, this move now only further empowers both the ruling dispensation and the agencies. What do you have to say on that?
See, in that case, if they feel that there has been misuse of powers, they need to prove it in the court. They cannot prove it on the streets. It has to be proved before the concerned court or before the higher courts to the judges as to what kind of powers have been misused. whether the laws have not been followed, whether they are not at all guilty. There is no prima facie case against them. There is nothing which has been found against them. There has nothing which has been done wrongfully by them. There is no sort of any money laundering in that particular case. This is what they have to prove before the court. If they are not able to prove it, if they are failing to prove it, obviously, if there is a prima facie case against any accused or a person or a company, the ED has certain powers as per the law to proceed. And this is how they are proceeding. Obviously, there could be instances where there is no prima facie case. In those kind of cases, many high courts have also given no coercive action orders. Many of the courts have also stayed the summons issued by the ED for any such probe. So this is what is happening. See, ED is not having absolute powers, but it has to be further controlled and supervised by the superior courts. And this is what has been happening as of now. So as per my opinion, if there is any misuse, it should be proved before the court of law. And we should have some kind of faith in the judicial system. And we should, have confidence in the laws which have been enacted by the parliament. These are the MPs who make the
All
laws.
right.
Right. So they only have made the laws. If there was something wrong with the law, they could have changed it in the parliament in these all long 20 years. This is a 2002 act. Now we are in 2022. Now we are asking the court only to first the parliament makes a law and then it demands changes from the court.
All right,
So
sir.
that is also has to be seen.
All right, sir, one final question before I let you go. What are the possible ramifications of this verdict and what are the options that are available for all the accused persons in such cases?
Yes, see, as per Section 45 of PMLA, one can apply for bail. There are two conditions to be fulfilled. One is that the public prosecutor in the case has to be given opportunity to oppose the bail, and the person has to prove that the person is not guilty of committing any sort of money laundering. And in these two conditions, if fulfilled, the court has the powers to grant bail to the accused. And in addition to that, a person can also approach the High Court for quashing of any such kind of summons being issued or to a stay if there is a prima facie case in favor of the accused and against the ED. In those cases, it can happen. If under Section 5, if there is any provisional attachment of properties by the ED, the same can also be argued upon in the court of the adjudicating authority. And if the person is not satisfied with the order of the adjudicating authority, can also be challenged before the appellate court. And thereafter, it can be further challenged before High Court or a Supreme Court. So all these options are available for anybody who feels that there has been wrong case being filed against that particular person and there has been misuse of any law. The laws and provisions are very clear. They have all the rights to approach the appropriate courts to get justice.
All right, yes. Mr. Ashutosh Srivastava, thank you so much for your time to Mirror Now. And definitely, so that's the latest that we're picking up. Remember, the top court in a very, very key judgment has only upheld the powers of the ED. And on this very note, in fact, we have another big breaking news coming in.